Can buying diapers or paying the other parent's rent count toward child support? Understanding in-kind child support. That's today's video. Many divorced and single parents wonder if directly purchasing necessities like baby formula, diapers, food, clothing, and other things that children need can offset their child support money obligations. This is often referred to as in-kind support, as opposed to simply paying the other parent money. So can a parent get credit for paying child support, so to speak, if he or she buys food or pays rent or utilities for the other parent and child? While the idea of providing direct aid to your child seems helpful, the rules in Utah surrounding credit for such contributions are quite specific. In the overwhelming majority of circumstances, a single-parent child support obligor's child support obligation is a financial one, meaning payments must be made in the form and only in the form of money. However, there are limited circumstances where in-kind support, defined as support provided by the obligor to the obligee in lieu of a money payment, might be credited. This could include buying food or clothing for the children, or even paying the other parent's rent or utilities. Childcare, however, is typically not considered in-kind support if you're providing care for your own children. The crucial factor is whether a child support order already exists. Before a support order is established, if there's no formal child support order in place and a parent can verify they've made in-kind support payments before receiving a Notice of Agency Action, an NAA, from the Office of Recovery Services, or ORS, those payments might be credited. This credit would apply to the current support ordered for the month in which the payment was made, up to the guideline amount for that month. For instance, if you paid $400 in rent for the custodial parent in July and the guideline support was $201, you'd receive a $201 credit for July, but likely would not receive a $199 credit for August. Payments in one month generally won't be credited for different or future months, or retroactively for that matter. When a valid child support order exists, this is where it gets more complex. If a valid child support order is in effect, in-kind payments are generally not credited unless the order specifically allows for them. In-kind support is ordered if your divorce decree or child support order explicitly states that you can provide in-kind support. For example, paying the mortgage instead of a cash child support payment. Well then, if that happens, you will receive credit for these payments up to the monthly support obligation amount. You need to have a written agreement for in-kind support, but not in a court order. If that happens, if the court order doesn't mention in-kind support, but you and the other parent have a written and signed agreement for in-kind payments, this agreement may be considered. However, this agreement must predate the custodial parent receiving cash assistance from the state, for example, in a 4A situation. Even with such an agreement, the case will likely be referred to the Attorney General's office for review, and additional criteria regarding court notification, undisputed value, and notice to the Child Support Services Organization, or ORS, will be considered. No written agreement and no court order? Well, if there's an existing court order for cash child support and no written agreement for in-kind support, then direct purchases like formula and diapers and clothing or anything else, even if the other parent asks you to pay for those things, will not be credited against your money obligation. The support obligation as specified in the order will be enforced as ordered. That brings us to the importance of written documentations. Under Utah law, any waiver of entitlement to receive funds in lieu of child support must be made specifically and in writing. This highlights the critical need for clear, documented agreements if you intend for in-kind support to count. Without it, your generosity in providing for your child's direct needs may not, frankly it likely will not, reduce your child support debt. The proof and the process? To even be considered for credit, an obligor must provide clear proof of payment made directly to the other parent. This includes canceled checks, money orders, bank statements, electronic payment receipts like Venmo or Zelle and the like, written receipts, or notarized statements from the custodial parent. The process for claiming credit involves submitting this documentation to the Office of Recovery Services, as I said, ORS, which will then review the evidence, notify both parties, and make a final determination based on the strength of the evidence provided. In summary, it's crucial to understand the legal framework surrounding child support, specifically what does and does not count toward meeting those obligations. Unless explicitly allowed by a court order or a clear written agreement that complies with law and made at the right time, then in-kind contributions to a child support likely won't reduce your obligation to pay child support in the form of money. Seek legal advice, good legal advice, before you do anything if you wish to explore alternative child support options and arrangements.